Hello, everyone. My name's Louise Keogh, and I'm chairing the seminar today as Paula O'Brien did all the hard work organising it, but is unable to be here today. So thank you, Paula. I'll start by acknowledging the traditional owners of the lands on which we meet today, the Wurundjeri Woiwurrung people, and pay my respects to elders past and present, and acknowledge the importance of Indigenous knowledge in the Academy. We're very excited to have this seminar today on abortion law reform in Scotland, lessons for reproductive rights advocates. This is the Health Law and Ethics Network's monthly lunchtime seminar, but it's co-hosted on this occasion by the Reproductive Justice Hallmark, of which I'm the chair, the Monash Health Law Group, the Deakin Centre for Law as Protection, and the La Trobe University School of Humanities and Social Sciences. So we're co-hosting the event. And it's also, Sally's here, funded by the Margunya Fellowship as well. So lots of people and groups to acknowledge today. So Lynsey Mitchell and Sally Sheldon will discuss recent progress towards the reform of Scots abortion law. And both were members of the expert group convened to advise the Scottish Government on abortion law reform. And so Lynsey is going to go first, and each are going to speak for about 20 minutes, and then we've got time for questions. So Lynsey is a senior lecturer in law at the University of Strathclyde in Glasgow, where she teaches jurisprudence and gender, sexuality and law. She has published work on the narrativization of women's rights in law and on how reproductive rights are often premised on the problematic reproduction of one-dimensional understandings of womanhood. She is currently completing a funded pilot project, Scotland's Abortion Laws, Understanding the Past to Inform Future Reform, and co-authored a report into decriminalisation of abortion in Scotland. And I'll introduce Sally as well, who's going to speak second. Sally is a professor of law at the University of Bristol, where she teaches healthcare law. She's written a number of books, including The Abortion Act 1967, a biography of a UK law, which we heard about yesterday, which was super interesting, and is currently a member of the team conducting research into contragestive time, the pregnant uncertainties in fertility control, which, if you're interested, there was a lecture about that on Monday. So I'll hand over to you, Lynsey.
Okay, so thank you very much for that very kind introduction. So yeah, as you just heard, I'm Lynsey Mitchell. I'm based in Glasgow in Scotland. And I just want to talk quite briefly, as we heard there, a little bit about what's been going on in Scotland. So I'm going to talk a little bit about where we are in Scotland, so what's been happening on the ground, so both politically, what's been happening in activist spaces, and how this sort of coalesces together. So a little bit of background, first of all, what's going on with the law in Scotland? Why might we need abortion law reform? So some of you may know this, some of you may not. So just to say that Scotland is obviously one of the four devolved nations in the UK, so it has its own parliament. And when the Scottish Parliament was set up in 1999, interestingly, health was very explicitly an area that was devolved to the Scottish Parliament. So it passes legislation, for all sorts of, healthcare, and it pretty much runs its own similar but different version of the National Health Service in Scotland. However, again, those of you who write about reproductive rights, reproductive justice, will be very familiar with the story of abortion exceptionalism. So although healthcare was devolved to the Scottish Government, an exception at the time was made for abortion. And this was to be reserved to the UK's Parliament in Westminster. So one of the reasons given was that this would help maintain a unified system under the 1967 Abortion Act, which applies across Scotland, England and Wales. Another reason that was given was it was said that some people were worried that perhaps politicians in Scotland, they might be a bit more regressive. What if they moved things backwards? So these were all some of the reasons given. Anyway, in 2016, power to legislate for abortion law was devolved to the Scottish Parliament. So it's actually only relatively recently in legal terms that this has really been on the political agenda in Scotland, because the government has not had the power to legislate. I mentioned the 1967 Abortion Act. Most of you have heard of this, you'll have come across it. It obviously applies in Scotland in the same way that it does in England and Wales. But the issue here is that the underlying laws in Scotland, and I'm talking here mainly about the criminal law, is quite different. So the 67 Act, if you're not aware of this, it didn't decriminalise abortion in Great Britain. What it did was it created a defence to the crime. And there's been a long-standing debate in Scottish legal academia that basically says the 67 Act was actually an ill fit for Scotland. So the argument goes that the 67 Act is basically crafted around the English defence, the English criminal offence, which is set out in the Offences Against the Persons Act of 1861. So that's a statutory abortion is a statutory crime there. However, that legislation doesn't apply in Scotland. The criminal law in Scotland is a little bit different. It's an entirely different regime. Abortion is a common law crime. Now, all of this is actually to say it's a fairly niche and fairly doctrinal legal discussion. And apart from probably a few scholars in Scotland, this is, it's not setting the world on fire. So, I'm not going to get hugely into the weeds. I mean, if anyone's really interested, there's some recent scholarship on this. But there's always been, there is this sort of level of antagonism that says, this doesn't work very well. So there's an argument that says that the criminal offence in Scotland is very different. The law has always been much more flexible. The law has always recognised a therapeutic exemption. And basically different people make different arguments with this. I mean, I've seen fairly recent arguments. Someone said that we don't even need to modernise the law in Scotland. What we need to do is get rid of this sort of overarching English legislation. And then the Scottish law would, it will work its way through. I don't think arguments like that are particularly helpful when you're trying to craft a modern healthcare regime. But these are just some of the arguments that have been going on. So anyway, all of this is just to say that it's a fairly archaic and not very well understood criminal offence. So it's fairly safe to say, if we can say nothing else about the underpinning law in Scotland, it's fairly safe to say that it's pretty much unclear. It's not very well understood. A group called Engender, which is Scotland's feminist organisation, it sort of does a lot of public advocacy on gender, although it is publicly funded. They've been campaigning for abortion law reform, and they commissioned a report last year into the state of abortion law in Scotland. They were looking mainly at the criminal law, and they said that abortion law in Scotland is outdated, it's harmful, and criminalisation is never in the public interest. And similarly, a recent academic paper that's just been published by a scholar at Edinburgh describes abortion law in Scotland as obscure, outdated, and largely unscrutinised. And I've just put this on the slide. This is an excerpt from Engender's report, just saying, look, the legal framework is made up of a patchwork of laws, some stemming as far back as the 17th century. So some of this can make for some interesting reading if you're a student or a legal scholar. It's not really a good starting point, though, if you're asked to advise a small organisation, what is the law in Scotland around dissemination of pills or something? It's not really helpful to turn around and say, well, we don't know. So this really sort of feeds into the need for reform. So where are we then? How likely is this? So in Scotland, does the political and cultural situation lend itself well to reform? So Scotland's quite a small jurisdiction. It can often feel a little bit overshadowed by its much bigger neighbour to the south. So this can often feed into a lot of kind of cultural ideas around exceptionalism, of things like Scottish culture, and there is often very much a rejection of anything that is perhaps seen as sort of an importation of things from England. And bizarrely, you tend to see this quite a lot within the legal profession. Perhaps some of the reason for this is that Scotland has always retained its own legal system, even following the Act of Union in 1707. So a lot of lawyers in Scotland and a lot of the profession, there is this sort of it can be a real clash at times when, it's seen that perhaps overreach from the courts or overreach from Westminster politicians. So although the Scottish legal profession is not known for being particularly radical, there is certainly a caucus among the legal profession who they would perhaps be quite receptive to reforming the law. And as I mentioned earlier, unpicking the 1967 Act. Some perhaps for helpful reasons, some for perhaps more obscure ones, but there's certainly some interest in that from among the legal community. Politically, many of you will be aware that there is a sizable independence movement in Scotland. We had a referendum in 2014. The result was 55-45 in favour of remaining as part of the UK. So despite this referendum supposedly putting the issue to bed, it really hasn't. So this has just been an ongoing rumbling. It's just constantly in the background of Scottish political debate. Since 2007, the governing party in the Scottish government has been the Scottish National Party, the SNP. And it prides itself on being a centre-left progressive party. The jury's probably out on whether or not that's actually true. But one of the issues that they have had over, the last few years, certainly, is that some of what they see as their progressive agenda or their progressive reforms have actually resulted in a bit of a clash with the Westminster government. So, a bill was passed by the Scottish Parliament, some of you may be aware of this, to reform gender recognition in Scotland. The Scottish Parliament on paper had the power to do this. However, the bill was blocked by the UK government. So there's been a bit of a sort of political collision course since then. It actually brought down the Scottish government at the time, and it led to the resignation of the then Minister. Similarly, legislation to incorporate the United Nations Convention on the Rights of the Child into domestic law in Scotland, that was similarly struck down by the UK Supreme Court and has had to be drastically scaled back. So politically, all of a sudden there has been this tension between, we're back to sort of classic public law. What are the powers of the Scottish Parliament? But with all of this feeding into sort of wider debates around exceptionalism or independence, there's all sorts of kind of interesting things going on in the background. So as I mentioned, abortion law is devolved. So on paper, the Scottish Government has the power to do this. The issue is, is this going to run counter to whatever is happening in Westminster? Now, there has been a change of government since these sort of previous clashes have happened. So it's unlikely that abortion law reform would be thwarted by Westminster, but I mean, Sally will be able to answer this question much better. It's probably worth just touching on then some of these sort of slight differences perhaps on the ground when it comes to sort of healthcare or health culture, if you like. So the procedure and protocol at the moment for abortion is generally similar in Scotland as it is to England and Wales because it's regulated, as I said, by the same legislation. But again, because health is a devolved area, the National Health Service operates slightly differently in Scotland. In terms of abortion care, some of the differences, for instance, are that telemedical abortion, or specifically early medical abortion, is available in Scotland up until 12 weeks. I believe it's 10 in England, but again, Sally will be able to correct us on that. And something that comes up quite often in discussions is that in Scotland, abortions are generally provided in-house by the National Health Service. There's not a tendency to use private providers. So there are some sort of slight, they're not major, but there are some slight differences. So all this is to say that developing what's been termed a particularly unique or Scottish abortion framework is something that does seem to appeal to politicians and certainly people working in public policy. So there is a demand for it. It's just about, making this happen. So all of that to say, how did we get to where we are? How did we get this report? Again, I'm not, mindful of time, so I'm not going to go into too much of a deep dive. Abortion's generally be considered a fairly quiet issue up until recently in Scottish politics and in society. We didn't have a huge grassroots movement. It's not something that's had a lot of media attention. It's not really something until recently that's been seen in need of legal reform outside of perhaps, feminist or academic spaces. There have always been some vocal anti-choice groups, but they've traditionally not been antagonistic. However, the recent influx of American funding and tactics has drastically changed that landscape. This has led to quite high-profile protests outside hospitals, which have received a lot of media attention. There's also been quite a successful media and activist campaign focusing on lack of access to surgical abortion, especially for later term abortions. And some of these individuals have usually had to travel to England. So activists have been keen, despite this sort of almost regressive turn and these quite aggressive tactics used by anti-choice groups, activists have actually been quite successful in leveraging these issues and again, perhaps elevating them in the political agenda. So what this led to was the Scottish Parliament passed legislation to create buffer zones, or safe access zones as we call them, last year, to essentially try and thwart these protests. I mentioned the feminist organisation Engender. They have been doing a lot of campaigning for decriminalisation of abortion in Scotland. And this, perversely, has actually been helped by huge media focus in the UK on recent prosecutions of women in England who managed their own abortions. So it's gone from something that, you really didn't read about this. It certainly wasn't something that was talked about or you would see in the media. But over the last few years, it's actually become something that, is really quite there within sort of public and civic discourse. It's probably worth mentioning, though it's probably a whole seminar in and of itself to talk about how did we end up with a government-sponsored review of abortion law? Someone said to me, this seemed to come from nowhere. I suppose the very, very short answer to this is that in some ways it did. It's probably almost an element of happenstance. I mentioned the sort of disaster that happened after the gender recognition legislation was thwarted. This brought down a coalition government. It led to a leadership election for a new Scottish First Minister and head of the SNP. So in 2021, there was a leadership contest and there were two candidates. And the media actually had a bit of a field day with both of these candidates because they both didn't have, they mentioned to the SNP sees itself as, quite progressive and pursuing centre-leftish sort of politics. And these two candidates both had perhaps not great records in voting for things like same-sex marriage or abortion rights. And they were both in their own way. They were both people who were well known to have different religious views. But again, the media had a field day with this. So I think essentially to get ahead of the campaign, one of the candidates, a man from Glasgow, Humza Yousaf, he is an Islamic politician and he did win the leadership contest, but he was getting quite a lot of attacks on his views on abortion and perhaps he just had better PR, but he came out and he said, well, if I am elected and if I win, I will convene a review on abortion law in Scotland. And it put a lot of the media attacks to bed during the campaign. He did go on and win the contest, but then he was sort of held to this. So there's a lot of kind of interesting, where would we be here would this all have happened had not for the sort of domestic political situation? I don't know. I'm not enough on the ball. So again, just to finish up, I'll speak sort of very briefly. Like, here is the expert group. So it was convened. Sally and I were members. It was very deliberately set up to be a group of experts. So straight away there were attacks before we'd even met, because obviously this meant that religious figures or people who were head of pro-life organisations, they were not members of the group. And this was, I think deliberate. But the group's remit was to review the law rather than having sort of wider discussions on abortion. So a group of lawyers, head of sort of medical bodies, clinicians, various people, we met for a year. The report was just published a week or so ago. But basically, it's quite a long report, and we did spend a long time looking at this. There are 36 recommendations, but obviously some of the most significant are things like, removing some of the sort of the patriarchal framework that we have. So a removal of the need for two doctors, a removal of grounds, and also to move to a situation where we are not going to be criminalising people for managing or self-managing their own abortions. As you can imagine, the reception to this report has been quite interesting. There are links here, but I'll not hugely go and click on them. I mean, you can if you desperately want, but basically you can imagine the sort of things that the right-wing media were saying. So there's been personal attacks on some of the members of the groups. This has been tied to the, independence politicians want to allow for, abortion up until birth. There's been criticised, all sorts of criticisms. But I think the thing that caught me off guard that they've really gone to town on is around the issue of sex-selective abortion. So this is something that the group, has been attacked quite a lot on. We've had to sort of make clear, it's like, well, this is not something that we are endorsing, but we have suggested that, yes, perhaps criminalising, people who do end up in that situation is not really ideal. But again, the right-wing media have had a bit of a field day. So there's been quite a lot of, as you can imagine, attacks and mudslinging. So I just want to kind of finish up just as a handover to Sally. So what happens now? Where do we go? I mean, this isn't I think the report is a huge achievement. I mean, maybe I'm just saying that because Sally and I and the others put a lot of work into it. So this seems great. It's all there. It's ready to go. We should just pass legislation. And yet, if you're a bit cynical, you can think, well, why have they published it now? What's going to happen? It's coming to the end of the parliamentary session. So the short answer is nothing, because we are due to have an election early next year in the Scottish Parliament. So essentially what the politicians have said is, well, we need to wait and see who is going to be elected, and it's all going to be left up to them. I'm sure you're all aware we're having a bit of regressive turn in UK politics at the moment as well. So whether politicians are actually going to be brave enough to deal with some of these attacks is anyone's guess. But I will hand over now to Sally.
Thanks, Lynsey, and thank you for the invitation, and thanks to everyone at Melbourne who's made me so welcome. So I wanted to talk a little bit about what all of this means for the possibility of reform in England and Wales, but also what it means for reproductive rights activism more generally. Reform in England and Wales is also long overdue. So our criminal prohibitions are enshrined in a statute that was passed in the midpoint of the reign of Queen Victoria, but actually carried forward statutory language from 1803. So we have very old, very onerous, anachronistic criminal prohibitions against abortion, and then the Abortion Act works against those. Lynsey said that abortion has been a quiet issue in Scottish politics. That's not true for England and Wales. So Westminster, the book that Louise mentioned, one of the things we did in that, which is the joy of having 2 years of research funding and some fantastic postdoctoral researchers, as we went off and we tracked every attempt to reform abortion law between 1967 and 2022, when the book came out, and we got to 61 discrete incidents where this had been discussed in Westminster. And actually I was doing a bit of back of the envelope updating for what that would look like now, and I think we're now up to 69 attempts to change abortion law over that period. So the Abortion Act has been consistently contested in the UK Parliament. But what's actually really interesting when you put all of those reform attempts together is the nature of that contestation changes in very interesting ways over time. So the early attempts at reform were all attempts to further restrict access to abortion. And then I'd say there's a tipping point in about 1990. And from then onwards, you get a gradual increase in attempts at liberalising reform, first very narrowly focused. And then over the last 10 years, those have become much more wide-ranging and much more ambitious. So in the last 10 years, we've had proposals for decriminalisation. And the attempts at restrictive reform are still there, but they now tend to be much more narrowly focused and much more focused on defending the abortion legislation, which is the Abortion Act, which anti-abortion advocates argue offers some few remaining paltry safeguards against abortion on demand and the opening of the floodgates further. So not a quiet issue in Westminster. So reform feels long overdue, and that's been given added urgency by a couple of things. So one of them is clinical developments, and particularly the early medical abortion service and the desire to make that a telemedical early medical abortion service, which became very important and very urgent during the pandemic, where it was just clearly safer and easier for pregnant people to be able to access those pills online. The other thing that's given calls for reform a greater level of urgency is a series of cases that Lynsey mentioned, the last of which to gain attention was the prosecution of this woman, Nicola Packer, who has been amazingly brave in speaking out about that experience and has got a lot of public attention for that reason. So these are cases where unexplained late pregnancy loss leads to investigation and, in some instances, prosecution because of suspicions that women have provoked their own miscarriages late in pregnancy using abortion pills. All of these prosecutions and investigations have been after 24 weeks, even though it would also be technically or actually illegal to use those pills outside of medical control before 24 weeks. But there's clearly some decision been made by prosecutors. And what happened to Nicola Packer was that she believed that she was less than 10 weeks pregnant. She was actually 26 weeks pregnant. She took the abortion pills. She provoked a miscarriage at that point. She was horrified. She packed the fetus up into a backpack and took it into hospital herself the next day to seek medical attention, and she was reported to the police at that point, and she was prosecuted, and a jury found her not guilty, having heard the evidence. So she went through this horrendous experience but has talked about it, and that's had quite a significant impact, I think, on public opinion, as you would expect, around this. And it's highlighted one of the challenges historically in arguing for what reform of abortion law in Britain is that people don't realise that abortion is a criminal offence already. So there's been a process of education to do before you can argue for the need for reform. So sadly, that is much less of a problem now because this law has been picked up and has been used. What we currently have in Westminster is a very limited reform measure, which has been brought to try and remove the possibility of women like Nicola Packer facing that situation again. So this is an amendment that's been tabled to the Crime and Policing Bill, which is a nasty, particularly punitive piece of legislation, and there's been some controversy and contestation within the pro-choice movement about whether we should be using that as a table for liberalising abortion amendments at all. But that decision was made, and a Labour MP tabled an amendment which would just very narrowly take women out of the criminal law, which would remove the possibility of prosecuting women acting with regard to their own pregnancies. That measure passed with a large majority in the House of Commons. It's currently in committee in the House of Lords. And I don't know if you will have heard this yet, Lynsey, either, is that one of the Tory peers has just tabled what looks to me like it's designed to be a wrecking amendment, saying, but this won't apply to sex-selective abortion. So this is the Labour MP's amendment is taking women out of the criminal law, making an exception, and the amendment that's been tabled to that, or that may or may not be selected and may or may not get voted on, is making an exception to that exception to say unless it's for reasons of sex selection. And I think that would just make that amendment pretty much unworkable. But I think, certainly the timing of that suggests that that's come as a result of reactions to the Scottish expert group's proposals. However, although we've only got that very limited amendment at the moment, it does seem that the climate is ripe for more wide-ranging reform south of the border as well. Public opinion has been gradually increasingly supportive of liberal attitudes to abortion. So this is British Social Attitude Survey data, which is very robust. They've been asking the same question in the same form since 1983. Abortion should be allowed where the woman decides on her own she does not wish to have a child. 78% of British adults now agree with that claim. However, one of the problems is that gets much softer when you push on particular issues. And if you asked a question about sex-selective abortion, that would get a very different kind of response. The other thing that's potentially troubling about those numbers is that there's other survey data, so less robust survey data, to suggest that young men are much less liberal about abortion than older men are. And I think that will relate in some way to the changing political context that Lynsey alluded to when she was talking. But pro-choice opinion seems to be quite strong in the British context. It's also the case that we now have a much higher proportion of female MPs in the House of Commons. So abortion in Westminster is always a conscience vote. I see no possibility of a government-ordered review that would mean government would take responsibility for dealing with this issue, which is so fundamental to women's human rights. So if we have reform, it's going to come via a private member's initiative. It will be a conscience vote on any legislation. However, we know that MPs' views are influenced by age, they're influenced by gender, they're influenced by political party. And Labour female MPs have traditionally been the ones who have defended the Abortion Act and then brought the more recent liberalising amendments to attempts to change it. So we've gone from 26 female MPs in 1967 to over 260 today, and 190 of those 263, I think it is, are Labour female MPs. So the parliamentary climate feels fertile ground as well. However, there are a range of problems. So one problem is disagreement within the pro-choice movement about the precise shape of future reform. It's much easier defending something that's there already than it is proposing something different, because as soon as you propose something different, you get down into the weeds of how do we deal with this particular issue, how do we deal with that particular issue. And it's extraordinary, or not surprising, but nonetheless extraordinary, the media reaction to the expert group in Scotland has picked on 2 or 3 tiny points in a report that's 160, 200 pages long. And that is, that's going to happen when you're developing reform proposals. So agreeing on something positive is going to be much harder, and there has been some disagreement within the pro-choice movement. We do face an active and much more cohesive anti-abortion movement because they are defending something from change, and that's easier. They are significantly better funded than they were 5 years ago, and we know that some of that funding is coming from the US. We have seen a rise of extreme right-wing politics, and those groups and those individuals are increasingly allying themselves with evangelical Christians. So you can see that the people who are leading the far-right movement are using Christian symbols, and that gives them a powerful way of opposing Islam and saying, we're not racist, we're opposing this religious movement, this religious body that we think is antithetical to our cultural values in different ways. So there's a strategic motivation for that, or grounding for that. We also face significant myths and misinformation about abortion and what liberalising reform would mean. So Lynsey's already talked about sex selection and the way that that's been represented in the press, which is quite a long way, as you can imagine, from what the expert group actually said about sex selection. And we face the problem that reform will likely rely, or has inevitably rely, on a private members' initiative. And that means that we face significant challenges in securing parliamentary time. So either you are just crossing your fingers and hoping that somebody comes, a sympathetic MP comes right up to the top of the ballot for bringing private members' bills. And do you have that in Victoria? Is there it's such a weird way of deciding what legislation gets introduced into Parliament. So either we're hoping for that, or probably more likely we're looking to table amendments to a relevant bit of government legislation. But either way, we're not going to have very much time. And actually, if you look at the example of assisted dying, which is also dealt with as a private members' initiative and a conscience vote in Westminster, a bill that's got through the House of Commons already is currently snarled up in committee in the House of Lords, and there are 1,000 amendments have been tabled to that as a deliberate attempt to block it by MPs opposed to it. The government's just given an extra 10 days of time for those amendments to be discussed, but you think even, 1,000 amendments, how is that going to work? So the hurdles are very significant. A few wider reflections. So the first one is the importance of movement building and positioning yourself to be able to bring legal reform or support legal reform before you get into the point of actually doing it. So that coalition building, I think, is always really, really significant. And that takes a lot of time. It takes a lot of speaking and listening to people, and speaking and listening to different groups, and building alliances and good working relationships. And that's really important. And I think probably we need to get better at doing that. We also need to be able to share robust data, informed analysis, and experience internationally. And I do just want to acknowledge the significant support that the expert group looking at Scottish reform was given by experts in Australia I don't know if Lynsey mentioned, we had the remit that was given to us by the Scottish government was that they wanted abortion to be treated as an issue of healthcare. And that meant, for me, that we were being very clearly directed to look at particular other jurisdictions when we were thinking about what reform should look like. And the various states of Australia and the different legal models that you'd introduced in Australia were really good models for that, because that was clearly very explicitly something that had been important here in different contexts. So that input that we had from Australian experts and experts from a range of other countries was really, really useful. And if you look at the recommendations that the expert group has made, you will recognise parts of Australian law in that, in terms of how those reforms have been framed. We also had to deal with misinformation from Australia, and other places. So one of the things that was reported actually in Parliament at the point that we were deliberating is that there had been a very significant rise in the number of late abortions in Victoria since decriminalisation and the changes that you were introduced here. And it was really helpful then actually to be able to reach out to experts in Victoria and say, is this true? And do you know where this number's coming from? And the number was actually coming from two academics based in Adelaide who had done some really bad statistics. Yeah. But that's really, you need those relationships in place so you know who to ask and you can get those things clarified. So I think building those international alliances are very significant and very important. And the other thing that I've found very helpful in thinking about law reform and thinking about international examples, and again looking at Australia, is we always, so you're thinking about removing old, anachronistic and bad abortion laws, and you're thinking about perfect, you're thinking about what you would put in place of them. And I think one thing I was very mindful of is this concern about abortion exceptionalism. And I want to give a shout out to a fantastic paper by Erica and Joe, who have really traced in a really interesting way, I think, how this has worked in Australia with these progressive reforms that have just built a new generation of problems by drawing lines in new places. So that's, I think, something that we can really learn from looking at other international examples as well. And I don't know, Lynsey, did you want to say anything else about wider lessons or not? Or should we? Okay, that's me done. Am I a minute within time?
Yes. Yeah. Anything else from that? No. Fantastic and so thought-provoking. I thank you so much. It was really interesting, and it does make me really glad that we criminalised abortion in 2008 in Victoria, because I mean it wasn't easy at the time and the politics was horrendous, but I think it would be even worse now, and we are seeing a lot of attacks on our current legislation as well. So yeah, good luck. Thank you so much for sharing that.